You're 34 years old and worth $400 million that doesn't entirely belong to you. Your name is on 3 buildings. Your company, Arcturus Capital, manages assets for pension funds, municipal governments, and university endowments. Widows trust you with their retirement savings. City employees trust you with their futures. And for the past 7 years, you've been quietly skimming from all of them through a layered system of shell companies, inflated management fees, and off-book transfers that your compliance team has been trained to look past. The hoodie you wore to your first investor pitch is still in your closet. Dark gray. You can't bring yourself to throw it away. Maybe it's the last honest thing you own. How did a kid from a 2-bedroom apartment in Cleveland end up here? Simple. Ambition without guardrails is just greed wearing a business suit. It started legitimately. You were sharp. You understood financial instruments the way some people understand music, intuitively, without effort. Your first fund returned 23% in its second year. Word spread fast. Institutional money followed. Then the 2018 correction hit, and your flagship fund dropped 11%, which wasn't catastrophic by any objective measure, but your investors didn't see it that way. They saw 11% and started drafting redemption notices. Losing wasn't an option. Not because you couldn't survive the loss financially, but because you'd built your identity entirely around being the guy who never lost. So you did something small. You misrepresented one quarter's returns by routing fees through a subsidiary to mask the underperformance. Just once. Just to buy time. That was 7 years ago. Devin Cole was already in your orbit by then. You'd hired him as a senior analyst 18 months earlier, and from the first week it was clear he wasn't like your other hires. Most analysts wanted to impress you. Devin just watched. Black hair, always neat. Black pants, dark navy shirt like he'd decided his look once and never revisited the question. He had this quality that was difficult to name accurately. He absorbed information quietly and filed it somewhere behind his eyes. He never asked unnecessary questions. That was the thing about Devin. He figured out when not to ask, which meant when he did ask, you answered honestly, because somehow you always trusted him more than you should have. He came into your office one evening about 3 months after the first manipulation. Everyone else had gone home. He set a bourbon on your desk without asking if you wanted one and sat across from you in the leather chair and said he'd noticed a discrepancy in the fee reconciliation for the Meridian account. He didn't say it like an accusation. He said it the way a doctor mentions a shadow on an x-ray. Measured. Clinical. You looked at him for a long moment. He picked up his glass and waited. You told him the truth. Not the full truth, but enough truth that he could fill in the rest himself. He nodded slowly, finished his drink, said, "I need you to never do that sloppily again." Then he left. That was the agreement. Never spoken directly, never written anywhere, just understood. With Devin managing the operational side, your system became sophisticated fast. You created 6 shell entities incorporated across Delaware, Nevada, and the Cayman Islands. You inflated management fees by routing client assets through unnecessary intermediary vehicles, each layer extracting a small percentage that individually looked like administrative costs. Pension fund managers are overworked and underpaid. They trust quarterly reports. They trust auditors. And you made sure your auditors were compensated generously enough to see exactly what you needed them to see. The money compounded. So did the exposure. But the exposure always felt abstract. The money was very concrete. 3 years in, your personal accounts held $40 million in assets that had no clean origin. You bought a house in Marin County, a second one in Telluride. You drove a matte black Range Rover and flew private when the trip was longer than 2 hours. Your investors thought you were eccentric. The press called you understated. The truth was simpler. You were careful. Careful the way someone who knows exactly what they've done is always careful. Devin would show up sometimes when you hadn't called him. He'd find you on the back terrace of your office building, staring at the bay. He'd stand next to you, no questions, and eventually hand you a drink. You never had to explain the silence. He already knew what was in it. Then Arcturus crossed $2 billion in assets under management. That was the threshold that changed everything, though you didn't understand it immediately. Above $2 billion, the SEC's examination cycle tightens. Routine audits become more granular. Risk-based reviews get triggered by patterns that didn't register at smaller scale. You knew this in theory. You'd planned for it. Devin had restructured the shell company documentation 6 months prior to the threshold, specifically to reduce the visibility of certain fee flows. But federal regulators are not pension fund managers. They are not overworked. Some of them have been hunting people like you for their entire careers. The first sign came on a Tuesday in March. Your compliance officer, a careful woman named Patricia who'd been with you 5 years, called you into her office instead of the other way around. That never happened. She'd received an information request from the SEC. Routine examination, the letter said. Request for documentation covering account statements, fee disclosures, and third-party vendor relationships for the past 3 years. Routine. Patricia said that word with a kind of careful neutrality that told you she didn't believe it. You told her to cooperate fully. You walked back to your office with your hands steady and your mind running scenarios. You texted Devin 2 words. He responded in 4. I already know. Come. He was waiting in the parking structure of a hotel 3 blocks from your building. Black pants, navy shirt, hands in his pockets. He'd already pulled the documentation trail on the 6 shell entities. He laid it out on the hood of his car and walked you through it with a flashlight like a surgeon reviewing imaging before an operation. He identified 4 exposure points, not smoking guns, soft spots, places where the paper trail had gaps that a motivated examiner could pry open. He had a remediation plan for 2 of them. The other 2 were harder. He said it plainly. Those 2 we can't fix without creating new problems. You asked what kind of new problems. He said the kind that turn an SEC examination into a criminal referral. You tried to control the process. You gave the SEC everything they asked for, exactly as requested, in the most cooperative and thorough manner possible. Transparency as a defense strategy. Your outside counsel, a firm you paid $400,000 a year in retainers, told you the examination looked standard. 18 months of documentation review with no unusual follow-up. The examination closed. You breathed. Devin said nothing when you told him. He poured 2 glasses and handed you one and sat quietly on your office couch while you convinced yourself it was over. He didn't look like a man who believed it was over. You didn't ask him why. Because it wasn't over. The SEC examination had flagged 2 transactions internally and referred the matter to the DOJ's asset forfeiture and money laundering section. You didn't know that yet. While you were celebrating a closed examination, a federal grand jury in the Northern District of California was already being assembled. A lead prosecutor named Andrea Marsh had been assigned. She was not the kind of attorney who lost cases. She'd spent 11 years building white-collar prosecutions, and her conviction rate was the kind of number that gets mentioned in the same breath as the name. She was 41, meticulous, and she had all 3 years of documentation your compliance team had handed over sitting in 32 bankers' boxes in a federal office building 6 miles from your house. The investigation moved in silence for 14 months. That's the thing nobody understands about federal white-collar investigations. They don't announce themselves, they gather. While you were expanding into a new fund vehicle and accepting speaking invitations and posing for a financial magazine profile, federal agents were interviewing former employees. Not current ones, former. The analyst who left 18 months ago to join a competitor. The operations associate who resigned after 2 years. The compliance junior who'd been quietly let go after asking questions about the Cayman entity. Each conversation was careful. Each was recorded. The agents were building not just evidence of the transactions, but a map of who knew what and when they knew it. A grand jury subpoena arrived on a Thursday morning. Not for you. For Arcturus Capital's corporate records. Every wire transfer, every vendor agreement, every board minute, every inter-entity loan document for 7 years. Your outside counsel called you before you'd finished reading the cover letter. She didn't say routine this time. She said you needed to come to her office immediately and bring nothing electronic. You walked out of your building in your dark gray hoodie and your blue jeans and white sneakers and left your phone on your desk because your counsel had told you to. Devin was already in the lobby. He'd seen you leave. He fell into step next to you without a word and walked with you to the corner before you stopped and told him not to come any further. He nodded once. He said, "Whatever you decide, I'll handle what I can handle." You didn't ask him what that meant. You already knew. The federal investigation had 6 parallel tracks running simultaneously. Financial forensics examining your wire transfer patterns against public trading records. Digital forensics analyzing encrypted communications recovered from devices seized under warrant from your third-party administrator. Witness interviews with 14 current and former employees, 3 of whom had agreed to proffer sessions with prosecutors in exchange for immunity considerations. A parallel SEC enforcement action seeking disgorgement of improperly charged fees. asset tracing through 4 domestic jurisdictions and 2 international treaty partners pursuing the offshore entities, and a tax investigation running through IRS Criminal Investigation Division, examining 5 years of personal returns. You had 6 problems. Each one was serious by itself. Together, they were something else entirely. Your counsel sat across from you in a conference room and explained something that your brain resisted accepting. The government had already built the structure of the case. The subpoenas and grand jury process weren't exploration, they were confirmation. Prosecutors don't typically convene a federal grand jury until they believe they have enough to indict. The subpoenas are gathering the last pieces to make the case airtight. She put a yellow legal pad on the table between you and wrote a number. It was the potential exposure if the charges were filed and a jury convicted on all counts. Wire fraud, securities fraud, investment advisor fraud, money laundering, tax evasion, conspiracy, 17 years. That was the floor estimate, not the ceiling. You stared at the number until the digits stopped meaning anything. Devin came to your house that Friday night. He knocked, which he almost never did. He was carrying 2 drinks in a paper bag from the place near the waterfront you both liked. You sat on the back deck for a long time without talking. The bay was flat and black and quiet. He'd been approached that week by a federal agent at his apartment building. A quiet conversation in the lobby. Nothing coercive. But the agent had known things about Devin's movements, his accounts, his relationship to you, that made it clear the investigation had coverage much wider than Arcturus's corporate records. He told you this the same way he told you everything, measured, like he was reporting weather. You asked him what he'd said. He said he'd asked the agent for a card and told him his counsel would be in touch. Then he finished his drink and said he needed you to understand something. He said he had always known what you were doing. He said he had never stopped it. He said that was on him, and he wasn't running from it. You didn't say anything for a long time. You watched the lights on the water. Then you said you were sorry. He nodded and said don't be, and handed you the second drink. The grand jury returned an indictment on a Wednesday morning. 12 counts. Your counsel had been in contact with the prosecutor's office and had negotiated a voluntary surrender arrangement to avoid a public arrest at your home or office. That was the best she could do by then. You wore your dark gray hoodie and your jeans and your white sneakers because you decided that if this was the day everything ended, you were going to be yourself for it. Your counsel drove you to the federal building in San Francisco. You rode in the passenger seat and watched the city through the window. The coffee shops opening up, cyclists crossing the bridge, people walking dogs, the whole ordinary machinery of a morning running completely indifferent to what was about to happen to you. Devin was already outside the federal building when you arrived. He was leaning against a concrete planter in his black pants and his navy shirt, hands in his pockets, watching you come up the steps. He didn't say anything. He just looked at you the way he'd always looked at you when the drinks were poured and the silence was the language. Like someone who understood what you'd built and what you'd broken and wasn't going to pretend either was simple. You stopped on the step below him and looked at him for a moment. You said his name. He nodded. You went inside. The processing took 4 hours. Fingerprints, photographs, a temporary holding area that smelled like industrial cleaner and recycled air. Your counsel sat with you through the initial appearance before a federal magistrate judge who read the counts against you in a flat, official voice that made 7 years of decisions sound very short when compressed into criminal language. The prosecutor requested detention pending trial given the offshore assets and the international entity structure. Your counsel argued for release with conditions. The judge set bail at $3 million secured, home detention with electronic monitoring, surrender of all passports, and no contact with any Arcturus Capital employee or former employee currently under investigation, which included Devin. The asset freeze had already been executed that morning simultaneously with your surrender. Federal agents had arrived at Arcturus Capital's offices at 7:45 with sealed warrants. They walked through your building with bankers' boxes, forensic imaging equipment, and a list of servers and storage systems identified in the investigation. Patricia, your compliance officer, had cooperated with investigators for the previous 6 months. She'd worn a recording device to 2 meetings. The forensic accountants had traced $112 million in improperly directed funds across the 6 shell entities. The offshore accounts in the Caymans had been frozen under a mutual legal assistance treaty request. Every material asset you owned was either seized, frozen, or under forfeiture proceeding. You sat in your counsel's office after the initial appearance, and she told you what the next stage looked like. Discovery would take 6 months. The government's evidence package would be substantial. Cooperating witnesses had already provided testimony consistent with the wire fraud and securities fraud counts. The strongest path, she said, was cooperation with the government, a proffer session, full disclosure, admission of relevant conduct. In exchange, the government would consider a binding plea agreement that substantially reduced the sentencing exposure. She said this was not a certainty. It was the least bad option available. You looked at the window behind her. The city was still out there, still completely indifferent. Devon entered his own proffer session 2 weeks after your indictment. His counsel negotiated separately. He confirmed his operational role in restructuring the documentation trail and his knowledge of the fee manipulation scheme going back 5 years. He received an immunity agreement in exchange for full cooperation as a government witness. When your counsel told you this, you expected to feel something sharp about it. You didn't. You thought about the parking structure 3 blocks from your office, the flashlight on the hood of his car, the 4 exposure points he'd laid out like a careful man identifying a problem he knew he couldn't fully solve. He'd always known where this was going. He'd stayed anyway. That wasn't loyalty to the scheme, that was something else. What, exactly, you were still trying to work out? The plea agreement was filed on a Tuesday morning, 14 months after your indictment. 8 counts reduced to 4, cooperation credit applied. Sentencing recommendations that your counsel described as the best achievable outcome given the scope of the documented conduct. You sat at a long table in a federal courtroom in your dark gray hoodie because your counsel had let you wear it, and you said the words the court required you to say: guilty, 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 guilty. 4 times, each time the judge confirmed your understanding, your voluntary admission, your waiver.